You do not want to buy a ticket, get to the airport, and find out too late that you were not allowed to travel. So here's the plain answer. A felony conviction by itself does not automatically mean a U.S. citizen can never leave the country. In many cases, international travel may still be possible, but the felony is only one part of the picture. The real issues usually come from probation, parole, supervised release, court orders, warrants, passport restrictions, or the country you are trying to enter. Because being allowed to leave the United States does not mean another country has to let you in. This is not legal advice. It is a practical checklist so you know what to check before spending money on a trip or risking a violation. I have a felony and I am legally restricted from traveling are not always the same thing. If you are a U.S. citizen, finish your sentence, are not on supervision, have no active court restriction, have no warrant, have a valid passport, and the destination country allows you in, travel may be possible. That does not mean travel is guaranteed. It means the word felony alone does not automatically close the door forever. The details matter. Are you still serving any part of the sentence? Are you on probation or parole? Did a judge order you not to travel? Is there a warrant? Does the destination country treat your conviction as a reason to deny entry? Those questions matter more than a simple yes or no. So do not assume your future is locked down forever just because you have a felony record. But if you are still on paper, the rules can change fast. This is where many people get in trouble. If you are on probation, parole, supervised release, bond, or under a court order, you may not be free to leave the state, the district, or the country without permission. Federal court materials list leaving the judicial district as a supervision issue for people on probation or supervised release, according to U.S. courts. That means you need to read your own conditions, not your friend's conditions, not something someone said online, yours. Some conditions limit travel outside the court's jurisdiction. Some forbid leaving the United States. And even if you already have a passport, using it without permission can still become a violation. A passport is not the same thing as permission to travel while under supervision. Before you plan a trip, ask your probation officer or parole officer. If travel is allowed, get permission in writing when possible. Do not buy tickets first, then ask later. A felony record alone does not always block a passport, but the State Department can deny, revoke, or hold up a passport in specific situations. Law enforcement may ask the State Department to deny a passport because of a valid, unsealed federal arrest warrant, a court order, a parole or probation condition forbidding departure, or an extradition request, according to the State Department. Federal law can also require passport denial or revocation for certain drug convictions when the person used a passport or crossed an international border while committing the offense. But not every drug felony triggers that passport bar. It depends on the specific offense and legal facts. Other issues can matter too. If your passport was surrendered during probation or parole, the State Department has a process for applying for a new passport or requesting return of a surrendered passport, often using documentation from a court or probation officer. And owing more than $2,500 in child support can block issuance of a U.S. passport and may lead to revocation. So passport problems are usually about active restrictions, specific legal triggers, or unresolved obligations, not just the word felony. International travel has two separate decisions. First, can you leave the United States? Second, will the destination country admit you? Those are not the same question. A valid U.S. passport does not force another country to let you in. Canada is one clear example. Canada says some people are inadmissible for criminal reasons, and an immigration officer decides entry when someone applies for a visa, applies for an ETA, or arrives at a port of entry. Canada also says impaired driving can make someone inadmissible for serious criminality, and a temporary resident permit may be needed with no guarantee of entry. That surprises people. They think it was a misdemeanor, or it was years ago, or it was expunged. But every country has its own rules. Old convictions, completed sentences, expungements, and misdemeanors may still matter depending on where you are going. So before booking, research the destination country's criminal record rules. Bring court disposition documents if travel is allowed. For complicated cases, consider contacting that country's consulate or speaking with an immigration lawyer. And if you are not a U.S. citizen, be even more careful. Green card holders, visa holders, asylum applicants, and other non-U.S. citizens can face different risks. A green card or travel document does not erase immigration consequences. USCIS warns that a person may be found inadmissible after leaving the United States if they have unlawful presence or a removal order, even if they have a travel document. If you are not a U.S. citizen and you have any criminal or immigration history, talk to an immigration lawyer before leaving the country. Before you travel, check your supervision status, court orders, warrants, passport issues, and the destination country's rules. A felony does not automatically mean you can never leave the country, but guessing is risky. One unauthorized trip can lead to a violation, denied entry, lost money, or trouble getting back. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsocietyhq.com for more information.